Thank you so much for coming to this panel. In case you're confused if you're in the right room, this is Beyond Color-Blindness, Confronting Legacies of Injustice. So appreciative of everybody in this room for joining us and for our esteemed panelists. Getting to the substance, I wanted to pick up on where Sherilyn Ifill left off in her amazing remarks last night. And I wanted to start a little bit with just the grounding of why we're here. So I'm here as ACS Director of Policy and Program for Racial Justice. And so I can name a few reasons that I'm here that are great reasons. One of the reasons I think that brought me to this role is that in 2020, as we all know, there was a huge resurgence of movements that came out of the murder of George Floyd, and all of our organizations, including ACS, including our government institutions, have begun to pay renewed attention to racial justice. I think there's been a huge shift in the way that we talk about it, and that's one of the reasons my role exists, one of the reasons I'm here. That's exciting. There's longer-term reasons that I'm here. I'm the child of an immigrant, so the birthright citizenship clause of the 14th Amendment, which the abolitionists fought for, was part of the reason I'm here. And I know that I'm talented in my own right, but part of the reason I'm here is also because as a black man, I was explicitly recruited by institutions throughout the course of my career. I had colleges and universities that actually were looking for me and were trying to cultivate a space where I'd not only be welcome and feel like I belonged there, but also teaching the kinds of critical concepts and ways of thinking about racial justice in America that have shaped my entire legal formation. So those are wonderful things. Many of them happened before I was born, throughout my career. Those are great reasons that we're in this room. We're also here because of some tough reasons, some pretty negative reasons. One of the most pressingly is that the Supreme Court this summer is very likely to revisit in a more negative way some of its racial justice precedents. We're looking at efforts to disarm Section 2 of the Voting Rights Act, which is one of the most effective pieces of legislation in actually increasing the power of people of color in the halls of Congress. We're looking at a very high likelihood that they will further restrict, if not completely get rid of, the very narrow existing interpretation of the Equal Protection Clause that allows institutions like private elite institutions, also public ones, to consider race along other factors and racial justice and how they're putting together their classes and who's represented. So that's some of the context I wanted to give, and I wanted to make sure in this conversation we had a chance, as Sherilyn Ifill called us to do, to go beyond the rabbit holes that the conservative justices of the Supreme Court have set us up to fail in, and actually get to the heart of what's working for us with equal protection, what's not, to talk about, as she said, and I thought was very exciting, what we actually truly really want and have space to dream, as it's becoming clearer that the structures that I've talked about have worked in some aspects and have also not, and also figure out, so what are we going to do about it, and how are we going to get to that vision? And that is a lot for the 53 minutes we have left. Thankfully, we have brilliant, esteemed panelists who I'll introduce now, who are going to lead us through that conversation and at least get us started, and I hope that these will carry on throughout the convention. So first, on the far end of the table, I want to introduce Jonadev O. Chaudhry. He has extensive experience representing tribal nations, tribal citizens, corporations, and individual clients on issues relating to commercial litigation, gaming, governance, tribal sovereignty, and tribal self-determination. He spent his entire career serving tribal nations and Native communities. In 2013, he was designated by President Barack Obama to serve as the acting chairman of the National Indian Gaming Commission, which required Senate approval, which he got. And in that position, he oversaw the $32.4 billion Indian gaming industry. He has also served as the Chief Justice of the Muskogee Creek Nation and as community organizer, adjunct professor, public defender, legal services director, and author. And I ask that you hold your applause till the end for all three of them. We have next Damon Hewitt. He's a longtime civil rights lawyer, social justice strategist, philanthropist, manager, coalition builder. He currently serves as the president and executive director of the Lawyers Committee for Civil Rights Under Law. Before that, he served as inaugural executive director for the Alliance for Men and Boys of Color, was a senior advisor at the Open Society Foundations, and before that, he had more than a decade as an attorney at the NAACP Legal Defense and Education Fund. He's also the author of a book, The School to Prison Pipeline, Structuring Legal Reform, and just incredible advocate all around. And finally, we have, right to my left, Lourdes M. Rosado. She's Latino Justice's 10th president and general counsel, the third woman to lead the organization. She has over 25 plus years of experience as social justice champion, a skilled litigator and appellate attorney. She successfully led advocacy efforts on several key issues, including the rescission of DACA, challenging the rescission of DACA, sorry, and challenging the enactment of the Muslim travel ban. She was named 2009 Citizen of the Year by the Philadelphia Inquirer, has served on the boards of numerous nonprofit corporations. So between the three of them, they're gonna solve our racial justice woes. Please give it up for our panelists. All right, so to get it started, I wanna first start with a look back into the present, reviewing how have our communities and organizations actually related the 14th Amendment to equal protection and to color blindness throughout history and today. I think there's a lot of false history to correct and truths to be told about where we are now. And I want to ask, what have been the successes and what have been the failures of the approach and the doctrine of the way equal protection has been approached in this country? And I'll start by turning it over to John and Jeff.
And thank you to ACS and Mr. Leslie for the invitation. Honored to be here and join you all. So that's a big question. I know we have a lot of ground to cover, but I think in order to tackle the question, it's important to talk about Native identity, just briefly. And when I talk about identity, identity is a hot issue within Native communities. And as you all are aware, there are many, many terms that describe the Native community, whether it's indigenous or Native American, American Indian, Indian. And a lot of these terms are kind of used interchangeably, but some of them have important meanings under the law. So identity, I think of identity as a three-part stool. There are different legs to identity. One part is kind of how you look, your outward appearance. And that can be the source of unfair treatment and discrimination, and your outward appearance as being an identifiable member of the Native community is one leg of the stool. Another leg of the stool is how active or engaged you are in your community's language, your ceremonies, your culture, basically what you do to be an active participant in the culture of your community. That's an important leg of the stool. And there are some people who are not identifiably Native who are very knowledgeable about their language and their ways. The third leg of the stool is what I want to talk about, is being a citizen of a tribal nation. Basically, being a citizen, being engaged in your nation's government in a way that all citizens are. And basically, doing the things that are required to uphold your citizenship and be an active member of your nation. Those three legs of the stool sometimes all exist at the same time in a given person, and sometimes a given person only has one of the three. But when it comes to constitutional law and how federal courts and Congress deal with Native communities, that third leg of the stool, your citizenship within a tribal nation, is the most important. The terms Indians and Indian have specific meaning under the law, and that meaning comes from the earliest days of the United States. That meaning comes from references in the Constitution and the Commerce Clause and the Treaties Clause to Indian tribes and Indians, and it references the pre-existing sovereignty of tribal nations at the formation of the Constitution and at the formation of the United States. So there's a lot of explicit and implicit references to the pre-constitutional source of tribal sovereignty built in the U.S. Constitution, and those terms and that pre-existing source of sovereignty interplay with the 14th Amendment all the time. And it's been very important for Native communities to uphold the distinction between the political classification of Indians and Indian tribes under the Constitution from the other considerations of the Native community with respect to the 14th and 5th Amendments. You know, when you talk about appearance or how you're treated based on being a member of a protected class, you're not necessarily talking about how you're treated based on your political classification. And that is extremely important. Right now, before the Supreme Court, a watershed piece of legislation, the Indian Child Welfare Act, passed in 1978, is being decided upon by the court as to whether or not it's constitutional. Opponents of tribal sovereignty are trying to make the act a 14th Amendment. They're trying to couch their attacks on the act in the 14th Amendment, basically saying Congress did not have the right to create this legislation that deals with child welfare because Indians are a protected class. On the flip side, tribal nations who understand the pre-constitutional source of tribal sovereignty being in the political classification, one that references all of the land that was given up within these United States in exchange for political agreements between the United States and tribal nations. Proponents of tribal sovereignty are saying, hold off, wait a second, the source of Congress's power to legislate in Indian affairs doesn't come from the 14th and 5th Amendments. It comes from the Commerce Clause and other references in the United States. So we could talk all day on it. I don't want to chew up too much time, but I'm looking forward to a very robust discussion. I'm honored to be on this panel today. Thank you.
All right. I'm captivated by that, so I'm focused. But good morning, everyone. Thank you so much to ACS. Great to see some familiar faces and friendly faces in the audience for this conversation. And I hope it is a conversation at some point. Look, for black folks, for black people, people of African descent in this country, like Native people, we've been through a lot. And we keep on fighting, keep on pushing. So, you know, the 14th Amendment itself, I actually want to go back kind of similar to John Dev, a bit of context before the 14th Amendment, to think about the struggle before that Reconstruction Amendment was adopted. And I think about Dred Scott v. Sanford, that black people have no rights which the white man was bound to respect. That was a struggle for basic recognition of humanity, given that chattel slavery still existed in this country, but also it was a fight for formal legal equality. And that fight for formal legal equality defined many decades of both litigation, advocacy, and eventually jurisprudence. We get to Plessy v. Ferguson after adoption of the 14th Amendment and the so-called separate but equal doctrine, trying to define what formal legal equality means, under what terms, under what conditions. Are they just words on paper? How does it manifest in real life, the lived experience? And then, of course, we get to Brown v. Board, which determines, of course, that Plessy was wrong outright, and that separate but equal, at least in the context of education, the court held, separate can never be equal, right? So what we realize is this battle for formal legal equality has been transformative in this country. It's the very thing that allows us to be in this room together. If you just look at the diversity of people in this room in terms of the phenotype of what people look like, how people identify if you happen to know them and their identity, right? That's what it allows, but it doesn't give us the justice we need, the justice we demand, and the justice we deserve. And so if there is a limitation of 14th Amendment jurisprudence, it is just that. It is how to evolve from formal legal equality under the law to justice. Now, I believe it. My organization is named Lawyers Committee for Civil Rights under Law. The freeze atop the U.S. Supreme Court, equal justice under law. That's what we as lawyers are all about. So I'm not trying to eschew that. What I'm saying is without more, it's actually insufficient, and that the context matters very greatly. We'll talk a bit more about this, I think, down agenda, but formal legal equality has led to and given us these notions, what people used to talk about a few years ago, a post-racial society. People don't say that so much anymore with the documented rise of white supremacy and anti-Semitic racism, all rooted in white supremacy, frankly, and anti-black racism. But people used to talk about a race, a post-racial society, because the desire was to be race blind. Remember Justice Harlan's dissent in Plessy. Our Constitution is colorblind. It sees no race, knows no color. And we know that doesn't actually match the impact of the jurisprudence. We know it doesn't match and reflect what people experience in our daily lives. It doesn't match even logic. You know, one of my clearest and favorite examples is people say, I've heard someone say rather, hey, I don't see race. I voted for Obama. Which is kind of funny, as if, you're, of course, you're righteous just because you voted for the person who was the good choice on the ballot. But also, if you think about it, what they're saying is, I'm not racist. I voted for the black man. Yes, you do see race, and there's nothing wrong with that. So to evolve from formal legal equality in the jurisprudence to true racial equity, we must see race. We must recognize identity, not as the social construct that it is, but as a function of self-determination of individuals and of a people. So I'm going to stop with that.
Cool, yeah. A lot there. Thank you again also to ACS for inviting me to be here with old colleagues and you. Good to see some familiar faces in the room as well. So for the Latino community, our engagement with the 14th Amendment Equal Protection Clause really begins with the case of Hernandez v. Texas in the 1950s. This is what's recognized as the first Supreme Court case to extend 14th Amendment protections to Latinos. And this was a case that was brought by LULAC on behalf of a Mexican-American man who was indicted by an all-white grand jury for the murder of another farm worker. And he was eventually convicted and sentenced to life in prison. LULAC appealed it to the Texas Court of Criminal Appeals, and they found that the 14th Amendment did not protect Mexican Americans or Mexicans as a group, that it only contemplated the white and black races. So SCOTUS reversed. They did not say that Latinos were a race. They didn't recognize Latinos as a racial group. But what they did say was that Latinos were entitled to equal EPC protection because they were discriminated against as a group marked by, quote, other differences from the community norm, what I call the othering test for shorthand. And the court also specifically said that's always a question of fact, right? So they looked in that case to all this evidence that was put on about how community members routinely distinguish between white and Mexicans in their speech, about restaurants and businesses that excluded Mexican Americans, about segregation in the schools. In one of what I think is a brilliant piece of lawyering, the lawyers for LULAC actually one lawyer put the other on the stand to testify to the fact that in that courthouse they were sitting in, there was two toilets, one that wasn't marked, and the other one was marked colored men and hombres aquí, men here, to show, again, the othering. Of course, the opponents were saying, the prosecution was saying, hey, what's the problem? Mexican Americans are white. So, of course, the SCOTUS rejected that reasoning. And of course, the holding in Hernandez does not square at all with a colorblind framework, because in order to ensure that someone is tried by a jury of their peers, you have to be conscious of issues of race, ethnicity, national origin, alienage, gender, all sorts of things. So we have seen in the Latino community, in the jurisprudence, this othering in several lines. I'll just talk about education to stick with that with one line of cases. So we've seen, starting with the Mendez case out in Orange County, California in the 1940s. This is a precursor to Brown v. Board of Ed. An 8-year-old of Mexican and Puerto Rican descent sued because kids of that descent were not allowed to go to school with the white kids. And the record there is, they were sent to a two-room shack, basically, for their education. And the record there was replete with incredible, first of all, racist and xenophobic allegations that Mexicans and Puerto Ricans did not have the same potential to become, thriving, productive citizens, that they were unclean. They even made allegations that they didn't speak English. I mean, a lot of these kids were born in the United States and raised and could speak English, and of course, no one in the school district tested them to know. But we see othering in other ways in the education line. So language was a big issue. My group started in the 1970s because a couple of Puerto Rican lawyers wanted to sue the New York City Board of Education for failing to provide bilingual education to Spanish-speaking kids from Puerto Rico. And then we saw a line of cases again where, the Equal Protection Clause was instrumental in finding that public schools had to provide bilingual education. Then, of course, immigration status was another othering that was happening, and we have the case of Plyler v. Doe from the 1980s, an important case where there was a Texas law that denied funding to school districts that were educating undocumented kids, and SCOTUS struck it down. They first held that undocumented children could claim the benefits of the Equal Protection Clause because they were persons within the state's jurisdiction, and they hearkened back to the holding in Yuk Wo, the case about Chinese wood building laundries back in the 1800s. Interestingly enough, and one theme that I want to come back to is the Plyler v. Doe still stands. It's an intermediate scrutiny case. But one of the keys to that holding was Justice Brennan made a point of saying that the legislation, the Texas law, really put an onus on innocent children for the parents' misconduct, and that just was not fair. It didn't comport with fundamental fairness. I want to come back to that idea of innocence because that is a theme line in a lot of this jurisprudence. And then I'd say more recently, actually in the 1970s, another case of othering that affected the Latino community was around income and school segregation, and that was the San Antonio School District versus Rodriguez case where kids in a school district of predominantly Mexican-American kids were getting about, school spending was about literally half per kid as it was in predominantly white, more affluent school districts. And there, unfortunately, the Supreme Court did not, said that didn't violate equal protection. So the record is mixed, right? I mean, there's a lot of arguments, and Marshall, in a beautiful dissent, talked about, the pretext, the center of the holding in San Antonio was that, states can relegate to local control. They can, they don't want to put all sorts of state regulations and control on local control for education. And just as Marshall said, of course, that's poppycock. There's a ton of state regulations. So it's been a mixed bag, for sure.
It's interesting hearing about it's tough when the past is a mixed bag. Like, we want to, some parts of this we want to hold on to. And one distinction that I heard as a kind of thread through all of yours responses was this tension between wanting self-determination, but also not wanting to be subject to oppression. And maybe we've made some gains on the anti-oppression front. Like there's certain explicit types of oppression that are, trying to be ruled out, but then maybe this resistance or real struggle around self-determination. And I want to, bring out further to the present and future, and what fallout do you anticipate from this decision, where it lands us?
Yeah.
And also, what do you really want the future to look like out of those, out of those ashes or whatever the remnants we're left with are?
Well, I can start. What we're worried about, I'm really, obviously we're really worried about a precipitous drop in admissions of Black and brown children to elite institutions. We know that this is going to happen. if the court does what we all expect, which is basically eviscerate race-conscious admissions. This was certainly the experience in Michigan and California after voters enacted by referendum prohibitions on race-conscious admissions, and Michigan and California both have incredibly prestigious school systems. I'll just say, and I'll pass it on for the for more horribles. Also we're really concerned about K through 12. A lot of our organizations are right now defending really laudable efforts by school districts to diversify the student body in magnet schools, those elite public high schools. Like I went to Stuyvesant High School in New York City, graduated in the 1980s. Stuyvesant, a couple of years ago, like their graduating class, this is a school where, I went to Harvard Day and Yale Day for when I was applying for schools. They would have, those institutions would have at the Yale Club and the Harvard Club in New York City to welcome all the Stuyvesant and Bronx Science and Brooklyn Tech students. We were recruited heavily. Those were pathways to Ivy League schools. A couple of years ago, class of 840, there were like 7 black students admitted in New York City, maybe a dozen Latino students. That's just untenable. And, New York City Board of Ed is trying to do something about it, and they were immediately sued. So really worried about K through 12 as well.
Yeah, what do we expect? I expect flawed and twisted readings of law and logic.
Yes.
I also expect mass confusion. Mm-hmm. Now, for context, every case, an affirmative action case for the last 20 years since Grutter, even before Grutter, they keep telling us we're going to lose. And we haven't.
Okay, that's true. Okay.
No,
Yeah.
but look, I'm not crazy.
No, you're right.
If you go to our website, lawyerscommittee.org, you'll see the first photo is me with our team walking outside, because one of our lawyers, David Hinojosa, argued the case. Thank you on behalf of UNC, Black and Latinx students at UNC, and I walked out like this.
Yeah.
Now, that photo I think is on our website. It doesn't mean I think we're going to win outright, but I think it meant we put on the strongest case possible. I think that it means we're going to continue to fight no matter what. Now, to the extent of the strong case, I think the UNC, I'm biased because we represented defendant interveners. That's why we got the ability to argue, although everyone told us we wouldn't. I said we got to get it, and we got it. Argument time. We think the case is so strong that there's not a scintilla of evidence of actual discrimination. But that's what also makes the case so dangerous, because the only way for the other side to win and for the court to do what it probably wants to do, the majority, is to actually make a Dobbs play and just throw precedent out altogether, just because. Stare decisis be damned. And Harvard is similarly so, right? We also were amici plus, represented amici plus status students in the Harvard case and put on witnesses at the trial to help develop that record as well. So that's what's scary about it. I mean, I think, though, I want to tie together, if I can, real quick, what is happening with race jurisprudence in this court. That could be, that's a theme, frankly, of this entire last two terms at least, if not 3 terms of this court. But there's some real odd things. So, as I said earlier, we're past the days where people say we're a post-racial society or that racism doesn't even exist. These days, it's more like, well, racism is out there in the ether, but good luck proving it. These days, it's more like the argument that, well, if you want to bring up race in a racial justice claim, then all of a sudden you are somehow injecting race, that you're doing something inappropriate. So, in the affirmative action context, you want to consider race? Oh, that's presumptively unconstitutional. You can't do that. Oh, no, I don't think you can ever do that. Oh, redistricting. You want to create another majority-minority district in the Merrill v. Milligan case? Well, I know the population supports having a second majority black district, but to do that and for Section 2 of the VRA, vote dilution, you actually have to consider race. But the Constitution, Alabama's Solicitor General tells us that, well, considering race is bad, and race should not be the main factor. So if your main outcome is to get a second majority-minority district, if that's your intent, then that's discriminatory intent. Therefore, you can't even enforce the remedial scheme of Section 2. Yeah. They're trying to tell us that any time race comes up, it doesn't matter. We filed an intervention last week in a case involving Medicaid. So this is not about the unwinding and other things that are happening, but Medicaid gives providers incentive pay for certain type of performance incentives. Last year, legislation added to that set of incentives, hey, if you create an anti-racism plan to actually try to eliminate or at least mitigate structural discrimination and provision of health care, then maybe you can get some additional points for merit. Number of states have sued. So we now have filed to intervene on behalf, and have survived a motion to dismiss. So we now have intervened on behalf of multiple NAACP state conferences across the country, Mississippi being primary, to try to stem that flow. Anytime race comes up, they're telling us it's bad. This is why I think this is all connected as well to the bans on books and the limits on school curriculum. We talked about Oklahoma, Jadeh, for a minute ago. It's an erasure game. That is the broader political project, to eradicate race and to essentially zap, limit, neuter the strength, the identity, the self-determination of a people. So that is the bad stuff. So what do we do if there's going to be some degree of bad, right? What do we do if it's pretty bad or if it's ultra bad? We've got to get back to first principles. First, we don't give up. Stare decisis, I do believe in, but there could be a court another day that does what Brown did to Plessy, right? That is certainly possible, right? So we don't give up on litigation, but also more general forms of advocacy, we don't give those up either. To go to the New York example, I don't know if you know, I actually was the lead attorney for LDF at the time when we filed the complaint about the specialized higher schools.
Oh, I do, yeah.
So I poured over that thing. We wrote it like a treatise because we wanted it to be almost like, a playbook for others.
Yeah.
And the thing I was most proud of, we did a report. You all helped, Latino Justice Pro Def, Community Service Society helped. The report was called The Meaning of Merit.
Yes.
And to me, this is what it is all about. It's all about how do we define merit. In our merits brief, no pun intended, in the Supreme Court, we made the point that normative criteria actually underpredict talent and potential of Black and Latino students.
Yes.
So shouldn't use of those normative criteria or overuse or sole reliance, in the case of New York, the unvalidated test,
Right.
shouldn't that in and of itself be a civil rights violation?
Right.
Why are we talking about consideration of race as a factor of a factor of a factor being a civil rights violation in and of itself? So will we get out of potential ashes, I think, would have to be something that gets back to first principles. Roscoe Jones, my board member over here from Gibson Dunn, Hill veteran. It would have to be getting back to first principles and saying to ourselves, each other, and to the world, we have to get institutions to redefine merit in a way that reflects justice so that there could be some facially neutral criteria that count. Last thing I'll say is this whole notion of eliminating consideration of race in any process, good luck. Because we know the research says, and ostensibly race-blind processes when people submit job applications, those aren't based on race per se, but people draw inferences. You look at the clubs you're a part of, you look at the name and people make assumptions about a name. I met a Black Shoshana the other day. You might have thought she was Jewish, but she's not. You can never make these assumptions, right? But people, we're meaning-making machines. We will continue to make meaning. Police will continue to use context and say that was a furtive movement because people look like a threat. I have 2 daughters and a very young son. I worry for all of them, but I also worry in particular about my son because I know the research from Dr. Phil Goff and others about the, I forget the full title, it's about lack of perceptions of innocence among young Black men in particular. 10-year-old Black boys are viewed as if they're 13 or 14. You don't get
Chris
to be.
Henning from Georgetown also has a book about
Yeah,
that.
Chris Henning does
Yes.
too. Yeah, The Rage of Innocence.
The Rage
Exactly.
of
She's
Innocence.
brilliant. And so you don't get to be a Black child in this country.
Yeah.
You get adultified. You don't get to be innocent. You just presume guilty. Or you don't get to be a resident or a citizen even. You're a suspect or a subject. So I better stop and save the time. But there are things we can get to from potential ashes, but we have to get back to basic principles of what's right, what's wrong, not just who wins or loses the case.
This is a fascinating panel. I wish we could spend all day together. So I just want to clarify one thing I said in my original discussion when I was talking about the 3 legs of identity and how political classification covers the 3rd leg of citizenship. This isn't to say that the Native community isn't fully engaged in the 14th Amendment battles that are still being fought to provide Native kids access to education, protection from brutality. I mean, these are absolutely our struggles too. When we talk about tribal sovereignty, however, you know, the tip of the spear doesn't always involve 14th Amendment battles. They involve Commerce Clause battles and battles to protect other sources of tribal sovereignty, such as treaties. But they're related and they're connected. And let me just kind of connect them really briefly, and I don't want to paint in too overly broad strokes. But if we think about the history of America, kind of emanating from one group with power and folks and the have-nots on the other side, you kind of think about two categories. Basically, how to deal with individuals in order for the haves to protect their power, and how to deal with resources for the haves to protect their economics. That's always kind of been the history. And when you're dealing with how the haves deal with individuals and maintaining control over power, equal protection is absolutely key to that. But when you talk about dealing with resources, one of the most important tools to protect the environmental future of the United States, the soul of the United States in terms of resources, is tribal sovereignty. And that battlefront is a separate battlefront from equal protection. When the Constitution was passed, there was quite a bit, I mean, when the 14th Amendment was passed, there was discussion at the time about whether or not Indians, as referred to in the Constitution, should be included specifically in the 14th Amendment to kind of wrap them into the political classification, you know, approach of the 14th Amendment, and the founding framers chose not to do that. And time again, the U.S. Supreme Court has upheld the notion that, the proposition that Indians and Indian tribes, as referenced in the Constitution, aren't part of the 14th Amendment. Those are political classifications. Why does that matter? In addition to my legal practice, I'm very honored to serve as ambassador of the Muskogee Nation. Originally, we're from Georgia, Alabama, and Florida, and we're now in Oklahoma. We're removed on the Trail of Tears. Many of you have heard about it. But at the time, we were a foundational civilization of the Americas, and we had a number of treaties with the British Crown and other European powers before the formation of the United States. When the Constitution as we know it today was ratified in 1789, the United States needed credibility on the international stage to show that it was truly an international power. And one of the sources of credibility is treaties, entering treaties with other governments, you know, and that's just one of the attributes of sovereignty. 1790, my nation was the first nation, native nation, and one of the first nations in the world to enter into a treaty with the United States. That Treaty of New York delineated the southern boundaries of the United States, and it was ultimately broken, but that was fundamental to the formation of the United States. That source of sovereignty, our ability to engage in treaty making, had nothing to do with the U.S. Constitution. It pre-existed the U.S. Constitution. Now, moving ahead to 240 years or so, the protection of tribal lands all hinges on the pre-constitutional authority of tribal nations. So when you talk about pipelines running through lands that Americans, non-Indian and Indians alike, have an interest in, waters that Indians and non-Indians alike, it's that pre-constitutional source of authority that's so critical. We saw that in Standing Rock. We see that in the Keystone Pipeline battles. And the tribe's abilities to protect against environmental racism, environmental injustice, hinges on that pre-constitutional authority. So let me tie those together. Okay, what what are avenues for attacking equal protection arguments and tribal sovereignty? States' rights. We see the states' rights arguments come up time and time again before the U.S. Supreme Court, arguments that the 10th Amendment somehow prohibits Congress from acting in a certain way to further the interests of equal protection or acting to legislate in the area of Indian affairs. And these 10th Amendment arguments have been, very potent in the civil rights battles of the 50s and 60s and 70s. But typically they've been losers in the federal Indian law space when they bump up against the pre-constitutional source of sovereignty. They've been losers for decades and decades and decades until last year. Last year, the U.S. Supreme Court issued a decision in it's in a case called Castro versus Huerta that looked at the kind of this very arcane area of criminal law, and the question before the court was whether or not states had implicit authority to prosecute crimes committed by non-Indians against Indians on tribal lands. The actual call of the question wasn't as important, but in finding that the states had inherent authority to prosecute these crimes, Justice Kavanaugh in the majority, in a 5-4 decision, found that based on the 10th Amendment, unless there was some other specific source of law giving tribes the powers to preclude this authority, the states presumptively had authority to prosecute. And in writing that opinion, he went so far as to say that the opinion's not dicta and that from here on out, tribes are parts of states. This is the first time that the Supreme Court ever said anything crazy. This crazy when it comes to Indian law. Okay, because obviously tribal nations existed long before the concept of a state ever was there, and that's been upheld time and time again in the U.S. Supreme Court. And in creating this new law, through all this mental gymnastics, much of which didn't even include legal citations, Kavanaugh has created a new analysis that the courts never used to put states' rights above the pre-constitutional sovereignty of tribal nations. That's so important, as for all the reasons you can intuit in terms of protecting resources. Now, you apply that 10th rights analysis to protecting individuals. We can all see where this is going. So to bring it full circle, and I'll wrap up with this, I was asked to talk about Brackeen versus Holland. Brackeen versus Holland deals with the constitutionality of the Indian Child Welfare Act, which was an act that recognized that in order to diminish and destabilize tribal nations, states had allowed for adoptions to run rampant in a systematic manner so that children were being pulled out of native homes, out of control of tribal nations. All going back to resources. If you're able to diminish and destabilize tribal governments, you weaken the ability to protect sovereignty, protect resources, protect the environment. And it's these tribal governments that are in the way of the haves that have always been there. So Congress passed the Indian Child Welfare Act in 1978, providing tribes with exclusive jurisdiction within their boundaries over child placement matters, but also with a responsibility for any court to consult with and work with tribal nations and courts for placements. That case is being challenged before the same court that issued Castro versus Huerta last year on 10th Amendment grounds and equal protection grounds. And it's where these two sources, all these sources of law come together. Tribal sovereignty, equal protection, and 10th Amendment. And tribal sovereignty must win, not just for folks who care about tribal sovereignty. It must win for folks who understand the history of environmental racism and the importance of tribal sovereignty to protect the have-nots in American culture. So thank you. Sorry for being so long-winded, but I just wanted to tie those battles together.
Thank you. That was brilliant. And thank you, all three of you. We're going to be moving to Q&A shortly so we can hear from some questions from the audience. A few threads that I heard across that were very interesting. It seems like a common interest in lifting up from individual rights and feelings, which are important, and maybe the court is better at recognizing, but also how these connect to things like the very meaning of merit and power and distribution of resources, and really seeing how those battles for justice are playing out. So I thank you all. The next code that you're going to want for the CLE is Elm, or if you already have Elm, it's Maple. So those are the two. Hold on. The second code is Elm. First code is Maple. And with that, I'd like to turn it over to the audience. We'd love to hear what questions you have for the panelists. And I've been told to note that Damon has a hard stop at 12, so he will need to run, but I think the other panelists might be around a little bit after the panel. All right, who's first?
Pretty good test.
Hi, all. Jonathan Diaz from Campaign Legal Center. I want to thank all y'all for being here today. So I work on voting rights and election litigation and advocacy, often on behalf of Latino and Black and Native voters. And a tension that I find often in my work is the push and pull between wanting to communicate the urgency of the threats to these communities and their right to vote and their constitutional rights, while also not demoralizing
Yeah.
people in those communities and avoiding defeatism.
Yeah.
And so how do you manage that tension in your work?
It's a great question, because it's a line that we're constantly navigating, the ringing the bell, the alarms versus not demoralizing. It really does come down a lot to narrative and what you're telling the community, to not be, yes, things are not good right now, things are looking bad, but there is a lot we can still do. So, you know, in terms of like the nitty-gritty as litigators, like we can, issues around education and contracting and employment, there's still laws. We can use Title VI, if not the Equal Protection Clause. We can, you know, even the most conservative justices have acknowledged that race consciousness could be utilized when there is evidence of past discrimination by the entity. And honestly, like, I think we're going to need to use that line to challenge legacy admissions in higher education, right? The fact that predominantly white student bodies come into colleges because they're sons and daughters or granddaughters of alumni, you can directly trace that to discriminatory practices in a lot of institutions. Challenging standards, criteria that are not actually shown to predict job performance or academic success. Relitigating cases like San Antonio to show that the income segregation that was happening in that case is really just a proxy for racial segregation. Like, there's still a lot we can do. And I think outside the litigation ring, I think there is a lot we can do as lawyers to cabin these decisions, and there is going to be a lot of craziness out there. But I think my message is to our community is like, that just means we're going to have to take more responsibility as our community to take this on, in our courts and more often in our legislatures.
That's a great question. I would say we can't show up like politicians who come knock on your door, come to your church only at election time. So we can't just, be Chicken Littles whenever there's a big threat in the Supreme Court or otherwise, or legislation or what have you. So we need ongoing engagement, meeting, not only like telling people stuff, educating them, but meeting people where they are and understanding day by day, week by week, month by month, what are the real issues that folks are facing, and how can we actually bring some value and try to improve those material conditions and structures. I think asset framing is really important. We have to talk as much about possibility as we do plight, because that actually has a negative impact. It starts to seep in, right? And it leads to defeatism, right? So we can't only say all the things that are wrong. Part of it is about having narratives that reflect people's aspirations, forward-looking things. Is it just, poverty, or can we talk about prosperity? Is it just, bad economics? Can we talk about actually, hey, could you in your lifetime or pass to your kids something that feels like wealth? I don't mean being like rich, quote unquote, but yes, something, a house, or in places where it doesn't feel possible, something you can pass on. Life insurance, is this something that you can have an intergenerational effect? Health in the here and now, and being here for your loved ones and kids. At the Lawyers Committee, we're doing strategic planning. It's my second year, so of course every ED does strategic planning. But the phrase that the concepts I have really kin to and we're really gelling on are about amplifying voice, increasing, to borrow a counter, visible pathways to opportunity, but also building power. And we're defining with community folks, what does that look like? What does that feel like in a way that you can taste and touch? Because folks have to have something to believe in. One last thing is, when we have wins, we have to celebrate them. Whether it's John Dev's win or whether it's Lourdes's win, we have to celebrate these wins, because what we're trying to do, we're a Black Senator organization, but we know we're trying to build a thriving multiracial democracy. So we do try to do work in coalition. So how do we actually build those wins together? And the last thing is super minute and tangible, but it's like we stopped talking about this. Can somebody get me a Sandoval fix, please, before we have no disparate impact left?
That's right.
B. Sandoval from 2001.
Yes.
It's defined pretty much my entire career practicing law, and it limits our ability to apply Title VI disparate impact with respect to institutions that receive federal funds. So I know it's a very specific thing, but I would love to see ACS and others really take that up, not just as a legislative lobbying issue, which I know there are restrictions on that. We're a C3 organization ourselves, but as a political issue, because we need statutory frameworks that speak to real lived experience. If all we can do is meet the Washington v. Davis intent standard for Title VI and equal protection, then it's going to take us years to build up one case that you may or may not win.
And I'll take a quick stab as well. I've got two buckets of answers, or two answers, one being very personal and emotional, and the other being more broader and political. But on the personal and emotional side of things, avoiding demoralization is a challenge, but in some ways it's easy for me, and I imagine many folks in this room, because we're still here. I mean, these battles between the haves and have-nots, and folks who see the have-nots as in the way of economic, supremacy. That's been the story of our ancestors for hundreds of years, and the fact that we're here is a tribute to their sacrifices, but also their successes in providing us an opportunity just to even live. And so whatever challenges we're facing today, they're part of a longer struggle that I think all of us can probably relate to, that have just allowed us to breathe the air today. So wins and losses taken in a historical context are greater, but they're also smaller. And so that's the personal, emotional side of things. On the political side, we have wins, we have losses. As crazy as I mentioned the Kavanaugh decision was, 2 years before that, we had one of the greatest wins in Indian law and in the court in the last 100 years. Some people calling it the greatest win, and that was the Oklahoma versus McGirt decision.
Right. That
That was issued by Justice Gorsuch, who isn't always seen as he's seen as more Kavanaugh-esque than anything else in other contexts. But in terms of Indian law and understanding the constitutional arguments that support pre-constitutional sources of tribal sovereignty, Gorsuch was a giant. an intellectual giant in that area, and he was joined by 4 other justices who politically you don't think are on the same side as Gorsuch. So we see wins through engagement, as fellow panelists mentioned, and this engagement also includes Congress. A lot of these 10th Amendment battles come down to separation of powers issues and avoiding the court legislating from the bench and allowing Congress to give life to tribal sovereignty, give life to the 14th Amendment. It's come down to separation of powers issues, and we have friends in Congress and on the court in those with those questions. But also in terms of community, I think the community consciousness that we've seen over the last few years around these issues is a source of spiritual edification and political edification. So being demoralized is always, fighting against demoralization is always a challenge, but we're still here.
Yeah, I just want to add one thing because Damon also reminded me this concept of power is so huge in the narrative. We do a lot of community education with Latino, folks, and one thing we always say is, we're almost 20% of the population, and probably more importantly, 1 in 4 youth under 18 is Latino now. So we have to remember that, because if we do get out there and vote, we can decide the agenda for this country.
I love it, and I wish we had time for more questions. I hope you'll grab the remaining panelists afterwards, and I love that note of gratitude, taking us back to the beginning.
Yes.
Gratitude for everyone who came before, gratitude for these 3 lovely panelists, and for you
Thank
all.
you.
Thank you. Enjoy the rest of convention.
Thank you.
Thank you.